Welcome. Hello. Welcome to our Covering Your Assets session presented by our Financial Education Ministry at Abundant Life Family Worship Church. We are so excited that you have joined us on this evening. You will not be disappointed. My name is Tasha Hogan, and I am the Financial Education Ministry leader. And we welcome you again. We welcome you on tonight's session. We have so much information to share with you on this evening. I hope you came with your pens and your pads to take all the information. And once again, we ask that you would tag someone and share this that will benefit from this, even if they can watch it later on, that they will benefit from the information that will be shared on tonight. We, as the Financial Education Ministry, I just want to take the time out to introduce you to our team that we have. Again, my name is Tasha Hogan. I am the financial ministry leader, also a facilitator. We have Tyretta Meadows, we have Cornell Fields, we have Monique Hurdle, we have Marvin Gray, and we also have Yolanda Darton, who is a part of our ministry, a part of the Financial Education Ministry. And I want to say that you will truly be blessed on tonight, and that we look forward to any questions and answers and give anything that you may have that you can always put in the comments, and we can address those questions as quickly as we can. We're going to get started on tonight. I don't want to hold up any much time, so I'm going to turn this session over to our facilitator for tonight, which is Cornell Fields.
Good day, ladies and gentlemen.
Hello, Cornell.
Good day, ladies and gentlemen. How are you all doing? Fantastic to be with Tasha, and thank you for that gracious opening to this session. We are really looking forward to the next few moments together as we begin to talk about and covering your assets and having a conversation that we think is poignant and important around estate planning and making sure that your affairs are in order. Before we get started, we want to take a moment and just, since we are Abundant Life Worship Church, we want to take a moment and just pray. And so if you would, let us pray. God, we thank you on this evening that you've blessed us to come into your grace, to come into your mercy, to come into your favor again, and to come into this virtual space and be edified. God, thank you that you would be in our midst on tonight, and that you would cause the words that would be shared to be uplifting, to be instructive, to provide systems and strategies that we may be able to move forward with strength and move forward with intention and purpose where our finances are concerned. We thank you for that in Jesus' name. Amen. So I want to provide you guys a disclaimer right before I bring on our esteemed speaker tonight. So I want to say the information contained in this session is general and educational in nature and should not be considered legal or tax advice. You should consult an attorney, a tax professional, or a financial planner regarding your specific situation. Okay? So don't take the information that you gather from here and run with it. You need to speak with someone personally about your specific situation. Amen. Tonight, our speaker is Yvette Taylor. She has 22 years of experience in the corporate world, including her service as a vice president of Prudential and as a general counsel for Cigna and Prudential. From that experience, she serves as a legal counsel to business owners, around business succession and planning, business formation, and business consultation. With her experience and expertise in estate administration, probates, wills, trust, power of attorney, and guardianships, Yvette helps her clients protect, preserve, and distribute wealth in a manner that best suits the requirements of her clients. Yvette is the author of Stop What You Are Waiting For, a step-by-step guide to estate planning. She also hosts a podcast entitled What's Your Legacy, which weekly provides estate planning tips along with insightful conversation with interesting guests. And so I believe we may be having a little bit of technical of difficulty. I'm seeing text coming through now. But she is on here and we want to bring her on if we're able to do so now. As we all know in this tech world, these things do happen from time to time. So we're going to allow her a few moments to get her technology squared away. And while we're doing that, I want to have Tasha come back and avail of some things that will be upcoming in terms of our calendar.
Sure. So we have upcoming our next session we will be having, and it's going to be a two-part session. Will be spending. I know people look at it's like a spending plan, and we're going to be doing a two-part session. Will be held by myself and Tyretta Meadows. That will be coming in December. Is our first session, and then our second session will be in January. It's going to be a two-part session where we'll be discussing several budget aspects. We'll be addressing how to spend your money wisely, how to save, how to allocate money where it needs to go, because we always need to know that our money does not control us, that we control the money. So we want to actually teach and show you that each dollar should have a place. Each dollar should have a place to go to. So that will be coming up. We are also working on for our 2023. I can't believe we're actually 2 months away from it. We're already in October, but the team is actually will be coming together. We're working on our 2023 calendar. So we were going to be having some good things, but just kind of bringing things together right now to kind of facilitate and see what we want to go. I know we're going to try to have something regarding real estate, home buying, entrepreneurship. So we look forward to putting those sessions together and presenting it to you all. And we just, trying to get things together right now, the financial education ministry at Abundant. And we just want to, I want to say thank you to our bishop and to our first lady, Bishop George Seawright and Pastor Mary Seawright, for allowing us to do this and to be our own in this ministry, to come to the people and teach. We so thank you, and we appreciate them. They support us, and we so appreciate them and love them. I'm just trying to see what's going on. See, I'm just, trying to facilitate going back and forth here at the same time. So we're hoping that we can have our speaker on, Yvette, on very soon. I'm just going to ask Cornell if he can come back in just to kind of give me an update. So just so we know what we need to do.
Sure. The speaker, we're having technical difficulties. She should be on momentarily.
Okay. So Cornell, so just as we enter into this session, and I know that we have the speaker for tonight, so can you just give us some good points that people, everyone probably would want to jot down, have on it and ready, where they can share this with their family members, grandmothers, aunts, uncles. Let that be the talk for Thanksgiving, since Thanksgiving is coming up. Let that be the discussion on Thanksgiving table. So just if you could just give us some, maybe 2-3 points that we can just probably look out and hear for when she, that's really important for us to know.
Sure. She's going to talk about a number of things, but I think one of the things that we need to key in on is that everyone has an estate. Like whether you've done the actual planning for it or not, everyone has an estate. If you own something, you have an estate. So when she talks about, getting your estate affairs lined up and in process, really begin to outline, and I'm sure will give us some homework, right?
Right.
So some of those things that need to be done is wills, and if you have kids, guardianship and living directives. So all of these types of things, as she begins to outline the various pieces of the estate plan, take note of that and jot those things down, and you can use those to reference back and make sure you walk away with some homework and begin to check those things off your list. So that's one. Two, you want to make sure, as Tasha just said, jokingly, that you don't keep this information a secret, right? We at the church want to share the gospel, the good news, and we here in the financial ministry want to share the good news about financial education and literacy. And so if you learn something tonight, don't keep it a secret. When you get around the table during Thanksgiving or even Christmas, don't keep this stuff a secret and share this stuff with other people, because that's how, we all get stronger. That's how we all begin to impact not only our immediate families, but our legacy. And so those are the two takeaways that I would say. Make sure you're jotting things down as she's listing off those items that you should have in your estate plan. And then don't forget at the end of this session to do that homework, schedule with someone and get this stuff in place. And then secondly, don't keep this gospel a secret. We want to continue to move the ball forward.
Yes. Good.
So without further ado, we've been waiting with bated breath. I want to bring on Yvette Taylor now, who's going to talk to us for the next few moments or several moments about estate planning. Welcome, Yvette. Looks like she may be muted, so we can get her unmuted.
Can you hear me now?
I have you now. There we go. We're like a commercial here. This is fantastic.
Oh, I was on another computer, and obviously I just need to stick with the old-fashioned way of doing things. But thank you so much for inviting me to present and share what I have a passion about, which is estate planning and its importance. And you mentioned in my introduction that I wrote a book when I first started this practice 18 years ago. I just thought that people needed to know they needed to know and understand, because to take action, people have to be educated. So my first part was educating. I did these types of presentations a lot, and wrote the book to get people to action. So I'm sharing information with you this evening, and it's very, you can put questions in the chat. I can probably see them as I'm talking, because the main thing about this information will be answering your questions, because I do it all the time. And sometimes I'm saying things that, there's just a basic question that somebody has. So feel free to interject those questions, and I will make sure to cover them. So thanks again. And I know that I sent some slides. You can put those up, or I can talk to them. Whatever makes it most effective for those present today.
All right, we're going to get those slides up for Yvette, and
as he's doing that, I can the main question that people ask is, what is estate planning? So can the slides be off to the side? I don't know. Those first few are just introductions. So I'll see how they look, and whether I might just ask for certain ones to be up for people to take note. It might have more information on it. But the question that's often asked is, what is estate planning? And it really is about coordinating assets distribution upon one's death, kind of managing your inheritance. And I always tell people 4 ways. So please write this down. There are 4 ways that property passes when a person dies. And what happens is we fail to coordinate those 4 different ways. And sometimes when people come to me and they do a will, they think they've covered it because they said, well, I said in my will where all of my assets go. The will only covers assets in your name only. So there's also beneficiary designation. And so if you designate a beneficiary in a insurance policy, in a 401k, mutual fund, then it's going to go to the person that you designated for that particular financial product. The third is joint ownership. And if someone is on your bank account, someone's on your deed, a lot of times I get people and I'm going through their assets and they said, okay, they've given me all their assets. And I asked them this question. I said, is your name on anybody else's property? And they'll say, oh yeah, my name's on my mom's deed, or my name's on, I'm like, well, that's also your asset. And we have to understand whether the intention is for you to be on that bank account or on that deed, so that you understand that you become a joint owner and those assets would go to either whoever the survivor of the joint owner is. And the fourth way that property passes is a trust. And that's something that you can potentially have in your portfolio when we do your estate planning. Not everyone would need a trust, but it is an important document and serves so many varied purposes. So that's kind of like an overview of when you come to do your estate planning, to understand the importance of, really just those 4 and coordinating those 4 ways that property passes. And so the question then, so why should I even bother to do estate planning? And the reason why is all about your legacy. You want to pass on the assets that you've accumulated during your lifetime. You want to take care of those that you love, or either the charitable interests that you had during your lifetime, what you might want to consider, and being able to make a statement with the assets that you've generated over a lifetime. So the why you want to do it is to make sure that those assets are properly titled for purposes of for purposes of your beneficiaries. I'm gonna give you an example of like deeds. They're just so important. I thought that there was I have a podcast called What's Your Legacy? And I interviewed the Register of Wills in Philadelphia. And she pointed out that there are a lot of deeds in Philadelphia that don't have the current owner or the person who is living there, paying the bills, paying the taxes, who thinks that they're the owners. Well, when one person passed, no one ever went through probate. They merely continued to stay in the house, pay the bills. Then they passed, and the next group didn't go to probate. So she would find deeds that they're calling tangled title, because in fact, there was never a probate done to transfer to the current owner over a period of time. And so sometimes it can go back for 3 or 4 generations. And that's a problem, because what then happens is unaffordable, or people who now own it can't afford to go through the legal process of getting that title in the correct person's name, because all of the opportunities to do probate over time just did not occur. So that is so important. If you can remember one thing tonight, is if there is someone on a deed that, someone on, when you look at all the deeds in your family, your personal household, your parents, your sisters, your brothers, etc. If there is a person who is deceased on a deed, then you need to take care of getting an updated deed, and don't wait until other people pass, because we lose so much wealth in failure to keep deeds updated. So That's just important, and I just want to make sure that people do understand. So if you go to the next slide, those are the we're talking about the why, how, and when, and the next slide will kind of reiterate some of the things. I've talked about the deed, I talked about beneficiary designation, and what can happen there. What happens a lot of times when I sit down with my clients, I say, okay, we're getting ready to go through the process, and I'm going to ask you to collect your beneficiary designations. And sometimes they'll say, oh, I already told you it's, my spouse and then equally to my children, or it's, they're not married, it's to my, brother and sister. And when they start going through the collection process, I'm not amazed, they're amazed, because I know what can happen. And people find out that I thought I updated my beneficiary designation. I thought I no longer had my parents on there, but my now spouse. Or I forgot to add one of my children because, they were born later. They never got on there. So keeping those beneficiary designations up to date, it's just a critical thing. And I mentioned already the joint ownership, how sometimes for convenience purposes, parents might put one child on a deed. I mean, not on a deed, on a bank account for convenience to be able to, pay bills and things like that. But what I tell them they can do is really, you can facilitate that through having power of attorney. So if someone wants to facilitate paying bills, if something happens, you want to do a power of attorney, not put a person on your account. Because if you should pass first, if you pass first, then that would go to that particular child, and one would think that children would share. Unfortunately, my experience has shown that that is not always the case. And then I did have a situation where a parent put a son on there, and it would have been better for him to be the POA. Well, and she was well into her 80s. Well, he died first. So we really don't know who will pass. And so what I had to do with her is write the Department of Revenue, because they were charging her inheritance tax on her own money. And so we had to show that all the money in the account belonged to her, and that therefore, there should not be any taxes imposed upon her because of the death of her son. But we had to go through that process, because placing someone on your account for convenience, you have to understand the implications of that. The other important reason to be looking at estate planning and fixing issues and problems that we see, social media and passwords. I do a lot of estate administration. So estate administration is when a person passes. I do estate planning, that's planning in advance, so that you have those documents in place. Estate administration is when someone passed and the family comes to me. And we can't get into, all of these electronic devices that we now have. Your cell phone, your laptop, your computer. A lot of your information is no longer on paper. And so you have to have a process within your family network on how to get into these important electronic devices. How do you handle your passwords? How do you share those passwords? And of course, there's all kinds of software now to help that. But I encourage families to begin to address that process. The other thing is location of documents. Before I go to that, I do want to talk about social media, because social media can take on a life of its own, even while we're live and we're, doing Instagram and we're over in TikTok and we're sharing something from Facebook over to LinkedIn. All of those things are going on. What happens if something happens to you? Until somebody goes in and takes down your profile, your social media life is still on. And a lot of families, are upset when they are unable to have that removed. But you have to have a process, and so that you can access and get in and then close it out. So I think it's just so important, and it saves a lot of anguish for the loved ones that are left behind, and doing these things if we take care of them. Location of documents. That is a really big issue, and I just want to make sure somebody could put in the chat that you can hear me and I'm not going too fast. Just any kind of feedback in the chat will let me know. Okay, so I'm being heard. The location of documents. I open up my discussion with the date that we meet, so we can begin to know that we're tracking the progress. Because once you get into my office, I realize that it takes people a long time. Sometimes people get to me and they're, they've had their third child and they meant to come when they had their first child. So my first thing that we do is we note the date, because I'm going to move you through the process so that now that you've come to me, it's now on me. You've put that burden on my shoulder to make sure your estate planning is done. And I take that very seriously. So we move through the process, helping you make sure to get your estate planning done. So the second thing is the location of those documents. So once you do the documents, we need to be able to find them. And I've had situations where people can't find the original will. And so we set up a process, and your original documents can be in one of three places. These are your options, not the refrigerator, freezer. I've had all kinds of things. They said the ice box because it keeps things. And no, here are the three options. Number one, they can be in a safety deposit box if two names are on the safety deposit box. And if you don't have another person like husband, wife, or brother, mother, son, mother, daughter, then the second option is you can get a fireproof box, safe. Home Depot, Staples is probably about a $50 or $60 investment. And it's a fireproof box, kind of like a safe. And you put your important papers in there, your estate planning documents, your deed to the home, and your title to your car. And so that is the second one. The third, we do have an option in our office. We maintain in our safe client documents, the original will specifically. So location of your documents, I can't stress how important it is. And I know you have your file cabinets and all of that. No, we don't want them in the file cabinets. It's not fireproof. You want to, you can keep a copy in there, but the original you do definitely want to have in one of three places. There's a question, because I talked about the deed. What is the difference between joint tenants with rights of survivorship and tenants in common? Thank you very much for that question. How you hold a deed. When you're married, husband and wife, is called joint tenancy by the entirety. And only husband and wife can hold that particular type of title, joint tenancy by the entirety. What that gives them, husband and wife, if something happens to one, it is automatically 100% the surviving spouse. So upon the death of one, the survivor is the owner. That's what tenancy by the entirety. Well, people have said, when they were putting all this together, well, what if you're not married and you want to hold it and you want to say the survivor is the 100% owner? Well, if you're not married, then it's joint tenants with rights of survivorship. If you want the other person on the deed to be the 100% owner, it has to have that language in there. And so I'm always looking at deeds when someone passes and the other person's living in the house and they say, well, now it's all mine. I said, let me see the deed. It has to have that magic word in there, joint tenants with rights of survivorship. That's the magic word. And then that surviving owner is the 100% owner. Tenancy in common. So you take those two owners and you say, well, we're buying this house together. It might be it could be just friends buying a house together. Well, I want my family to get my 50% interest, and the other person wants their family to get their 50% interest. And then you would hold it as tenants in common. And it defaults to tenants in common if you do not have those magic words with rights of survivorship. So if I don't see the with rights of survivorship, it's going to be it's going to be a 50-50. And if you have 3 people on there, to be 1/3, 1/3, 1/3. And if you have 3 people on there and it's with rights of survivorship, then upon the death of one, 2 people own it. Upon the death of that one of those 2, the one person owns it. But tenants in common, 3 people own it. Upon the death of the first person, their assets go to whomever they leave it to. They could leave it to these 2 people, or they could leave it to anybody else. And the same thing when the second person dies, their interest will go to whomever. Now, this is where you get really complicated titles when people are not doing their probate to take care of things, and you have several owners on the property, and it's all tenants in common because there's no rights of survivorship language that was on there. And so somebody passes and they have 7 children. Now, these 2 people are also, their other 1/3 is owned by 7 people. 7 people own 1/3. And trust me, I have seen it where it's been so complicated, where, we're trying to determine who owns and how many owners are there and how we can get them together to agree on how to handle the property. So thanks for that question. I really do appreciate it. And there was a question, can you give an example of why someone would need a trust? And that is a very good question. I will tell you, when people come into my office and I tell them, I said, the primary reason why I do a trust is if you have real estate, not only in one particular state, and I know I'm talking to your church, which is located in New Jersey, and of course I'm a Pennsylvania attorney, but I'm keeping it global in the discussion. So I'll say to people, if you have property in the state where you are currently living, say New Jersey, and you have property in another state, and a lot of people in Pennsylvania happen to also have property in New Jersey because they have Jersey Shore property and all that. And so if you have property in more than one jurisdiction, a trust is very important, because a trust avoids probate. And if you have property in several jurisdictions, you have to probate in each and every state where you have real estate. When you do a trust, we combine it all into one document, and you don't have to go to probate in the state where you live, in the state where you have these other properties. You merely follow what the trust document says as it relates to how you want that property distributed. So that's the primary reason that I do a trust. And that is what I call revocable living trusts, because there are other types of trusts, and I'll talk about those. And those types of trusts are done because we want to address that situation. You might have a special needs child, so we do a special needs trust. So we'll talk a little bit about that. But for the revocable living trust, number one reason is if you have property in other jurisdiction. The second reason is if you have an interest in privacy. You don't want your information all, filed and made public. When a person dies, their will is filed. It is a public document. Anyone who wants to go to the Register of Wills and look at a file, they can. So, but a trust is not filed, because the will is filed because probate means to take a will to the Register of Wills and have it probated. So probate means to prove a will. And you don't have a will, we have a trust, and you don't have to go and file it. So it's not a public document. So some people have the privacy issues. And, I used to do a blog before I did a podcast, and I used to blog on wills of the rich and famous, because I could get a will anytime, but a lot of them did their estate planning and they had trusts. So the essence of their estate matters was in the trust document, which isn't filed. And for privacy purposes, that's why they got a trust. So that information is maintained in that way. A third reason for doing a trust, if that applies to you, is for ease of administration. Let's say for seniors, and two categories of people with businesses, ease of administration, and older people, elderly people, if you've just lost a spouse and now you want to make it easy for your children to handle your estate. And so for ease of administration, everything is placed in a revocable living trust. So when that person passes, the family just looks at the trust terms, they don't go through probate, and then they're able to manage the estate. Now, I will say Pennsylvania is not a difficult state to probate in. So I don't merely want to do a trust for you because you don't want to go to probate. I explain that you can still get a trust, but don't you say because it's so expensive and time consuming. In Pennsylvania, that's not the case. In New Jersey, it's not highly noted as a state that's difficult and costly, but states like Florida, California, Illinois, New York, those states on a national scale, when a lot of people listen to Susie Orman, who recommends trust, and I thank Susie Orman because a lot of people come to me because of that, but I do educate them because I'm not going to give anybody something I don't think that they need, because I want them to be very happy with using my services, because it's all about me taking care of them. So if they need it, surely, but I do educate them because I'll break it down. When you listen to Susie Orman, she's given a national discussion, and now you're right in this particular state. So let me tell you about this state. But so those other states, those big states, people need to have a trust. And so those are the kind of like the primary reasons for having a trust. When I said something about businesses, ease of administration, remember I said elderly person, as well as a person, business owner. If you're a business owner, you have a lot of things going on. And if you've set up an LLC or an S Corp, which is what I would be recommending that you do, then there are some opportunities for you to use the trust vehicle to make the transition easy for the family if it's not really already covered in your limited liability company documents or your subchapter S. And so the business aspect of estate planning is just as important. I end up doing a lot of business succession planning. If you've taken time to build a business, the last thing you want is to lose all of that hard work that you've done and that your family can take advantage of. Your family might not be interested in following in your footsteps. Sometimes you do things and your children are just not interested, but only you can provide an avenue for where that business might go, given the fact that it's not something that your family is interested in, but they should be able to get the money from a sale. But only you are in the best position to be able to categorize or have notes or some sort of relationship for transitioning your business for those purposes. But yes, thanks for the question about the trust. The other thing we were talking about, long-term care. Long-term care insurance, it is important. It is, I know it's costly, but in recent times, there have been some new financial vehicles to help facilitate the affordability of long-term care insurance. For example, there are insurance policies now that can be converted to long-term care if that long-term care need should arise. Otherwise, it would be your life insurance and available to the family upon death. So you can do some creative things with life insurance to handle your long-term care. And the reason why I mention it is over time, when I would look at people's assets, and then we would have a question come in when a parent has a long-term care illness, whether it's a dementia, and there are also, a lot of kind of, let me see, I was trying to think of some particular one that people get, but it might be something in their family line that so when a person gets that, you can wipe out a really good, estate. We looked at all your assets look really wonderful, but if you get a long-term care illness and and your care is $10,000-$15,000 a month, it can really do havoc on anybody's estate. So we try to make sure that we're planning, we're thinking, how we're going to address that. Are you going to be self-insured? That's looking at your assets, and do you have enough? Or is there an opportunity for you to get the right kind of insurance? And the special circumstances will be when I talk more about trust, how to deal with those special circumstances, whether special needs child, whether you have a residence that you want to keep in a trust because you want to keep it in a family. And so things like that will come up under special circumstances. The next slide, we are just talking about the will and what makes a will legal. A lot of times in my estate administration, and that's why all of this goes hand in hand, you learn with my estate administration practice what I have to do to make sure my will does not fall into some of the traps that happen. And so because people will challenge the will. And so basically what it is, you indicate how you want your assets to be distributed, and it has to be signed at the end of the will, and then it has to be witnessed. And people often in my office, we get the document notarized. What the notarizing the will does, anyone who serves as a witness, if the document is notarized, we do not have to find the witness upon your death for them to affirm that was your signature. So if you don't get the will notarized, we're trying to track down witnesses. And obviously that's a difficult thing because, people move and people may have predeceased the person doing the will. So it is important that you have a will fully signed, witnessed, and then notarized. Those are kind of the formalities. I talk about videotape, and the will is a written document. A videotape is when you know that there's going to be family disharmony, that this is not what mom would have wanted. My dad didn't really do that. And so sometimes if a family member anticipates that, they may say to me, can I just be videotaped and you ask me some questions, and then I can have that tape with my documents. And so my family can look at it, and it will deal with some of their issues and saying, well, he must have been incapacitated to say that, or he would not have said that. And the will and a videotape, especially, this is obviously when people go all the way and they want to challenge something in court, that these are kinds of documents to support the fact that the person was of sound mind and body. They were not insane, and they made these decisions because this is what they wanted to do. The biggest issues obviously come when you disinherit someone. Now, for a spouse, they have a right under the law, if you disinherit them, to get what they call under the law their intestate share. So they have a share of 1/3 of assets in your name only, if in your will you disinherit them or not give them enough of what they felt that they should be entitled to. So the only person that you do have to watch out for or provide for is your spouse, not your children. It is not legally required that you leave anything to your children. So, and sometimes children don't understand that. Well, and they definitely don't understand it when you leave it to some other people. And so, or leave it to charity. They don't understand that either because you must have been insane. And so we have to go through those things when we anticipate that you want to do something. Then I said, good, that's your choice. I said, but you've already told me that your children are going to take objections with this. And so we need to show them that this is what you wanted to do, and you have every right to do that. And even if you have 4 children and you only want to leave them to 2 children, yes, you can do that. And then you also have to be prepared for those other 2 children and want to challenge it. And we make preparations for that we say in the will that I didn't forget these two people. I have intentionally left them out. And sometimes we say a reason. We might say, because I took care of them and I, adequately took care of them and I'm not interested in giving them any more, or we have been estranged since, for 20 years and that, so, but like, once again, you're not required to provide for your children in your will. So, but you can make those statements if you feel that would be helpful. A memorandum. A lot of people have things. We have a lot of items, stuff in our house, and we love them. Oh, they mean so much to us. And so I tell people, well, in the will, we're not going to really go from room to room saying, I want this person to have that and this person to have the other. But if it's sentimental value, if it's anything like jewelry and, first of all, money, real estate, jewelry, automobiles, things like that. Yeah, that's going to be in the will. But I have people who have, a collection from, this was handed down from their grandparent. And so it has sentimental meaning. And they want maybe the daughter to get this, and they have something that they want the son to get. And then they're buying more things and they want to continue to make some sort of distribution. So I tell them that you can have a will that says basic covers everything. And then you have this special memorandum. It is not a legal document, and it is not technically if they did not follow that, your executor did not follow that, it's not a legal document that we can then challenge the executor in not doing that. So if it's really important for you, you have to put it in the will. But if you know that you picked an executor who will make sure that the china set goes to the individual that you want, then those things are fine. But I usually do put in the will as I'm talking to a client that there's something they're really attached to, then I want to make sure it's covered in the way that they want, and we put it in the will. But I'm just saying, I know we have lots of things and how we want to handle that in different ways. I cannot stress how important it is to be to have your will and your intentions known. And yeah, we talk about assets in your will, but another important asset, your children, right, when they're young, and you want to make sure you have a guardian, and that's super important. But your body is an asset. I mean, we've heard, especially when you look at, people in the news and stars, and they die in one country, and, and they have this child and that child, and where their body, what do you want to do with their body? I know Michael Jackson was held for a period of time as they, wanted to deal with that. And Anna Nicole Smith was the same way. I mean, so your body is an asset. I had a situation only a month ago where an estranged daughter, who was alleging she was not estranged, challenged the funeral home in proceeding with a funeral that was scheduled by the son who the father was living with. And because the funeral home, and because there's a funeral law that says if there's a disagreement, then they have to go with the majority. Well, this man had a son and a daughter, and so there was no majority, and so we went to court. And they had people coming from the West Coast, Washington State, California, already with their tickets, ready to come to a funeral. And we were going to the funeral. The wake was going to be a Friday night. We were going to court Thursday morning to make sure that the wake Friday night and the funeral on Saturday was going to be permitted. And so they were on pins and needles because, she was challenging it, and she really didn't have any basis, but she just wanted to disrupt. She was very angry with her brother. And so this was her way of taking out. So in this case, there was nothing in the will that, sometimes if you write specifically what you want with your body, then no matter if the two of them disagreed, the writing of the person would have prevailed, and we would have been able to follow that. So I often encourage my clients to state what, because some of them do state, because especially when they want to be cremated, they do state that, they put that in a will so that can be followed. And so you want to really think about that and consider that. And especially if you don't have an odd number of children, like 3 or 1 or 5, then you want to make sure. And I know people say, oh, they know what to do when I die. It's all understood. We make too many assumptions. So next slide. The role of the will is to name your executor, name the guardian of your children, name the beneficiaries who you want to take, and name whether you want those assets to be given to them outright or maintained in a trust. And when you have minor children, it will be maintained in a trust. So you not only name the guardian to take care of the children and have the body of the children, but you also name a trustee to take care of the assets that you have left for the children. And then when we talk about the will, I see there's a question, must I file my will in states where I own property? No, the will during your lifetime is not filed anywhere. The will is filed upon your death. That's my general statement. There have been I had a client that moved here and moved to Pennsylvania and said that in her, and I'm trying to think whether it was Maryland, and one of the counties in Maryland, you could file your will. And so I told her, that was unusual, but if a county wanted to facilitate something like that, they could do it. The problem is, just like with anything else, you file a will and then you change it and you never file the new will. And now we got another problem. So no, in Pennsylvania, and I'm not aware of any county in New Jersey where you file it during your lifetime. It's something that you file upon your death. And your question as it relates to where I own property. Now, I say you file it upon your death. If you own property, New Jersey, North Carolina, Florida, Georgia, well, then we're probating in New Jersey, and then we have to go to Georgia and Florida and make sure that we probate because we have property in those states and they need to see the will too. What happens is you probate in this state and the state provides you with what they call ancillary probate papers. And those ancillary probate papers then open up probate in Georgia, Florida, and North Carolina. So obviously that's why I said you want to do a trust. And when you have properties like that. And so so the next part, what other ways can assets be distributed at death? We did talk about that. So this is just a test. I said 4 ways: will, beneficiary designation, joint ownership, and a trust. So, and when you should make a will. My youngest clients are 18, and I'll tell you how I get the 18-year-olds, because the parents, when they're getting ready to go off to college, their kids are getting ready to go off to college, they realize that they do not have right to access information and documents relating to their child without their child's permission. So they want to know if their child can get a power of attorney. And I say, yeah, they can get power of attorney, but remember, parent, that they are that person, when your child comes in, that child is my client. So I will ask them, who do they want to be their agent? And you're assuming that they will say you, and your assumption may be correct, but I just want you to know that I will put who they say into the documents. And I do know that ultimately who's paying the bill for the child would be you. So anyway, in most cases, the children are coming in so that their parents can have power of attorney to handle financial affairs for them, as well as handle talking with doctors if they have a medical situation. And so that's so when you can make a will. So my 18-year-olds, when I'm talking to them, unless they've already have a job and already accumulating some assets, and And it happens. I mean, we have some young people, they're doing new kinds of things and making money. And I said, well, you need to have a will because, do you want everything to go to your parents? Do you have some sort of charitable thing that you're doing? And so you can make a will at 18. What happens once you do a will, I tell people it's not once and done, because sometimes it takes people a while to come and get their document done because, oh, I don't know who to name as the executor. I don't know who to be the, who could be the trustee or the guardian of our children. I say, take a picture today and we do the document based on today's picture. And remember that you can update the documents, tomorrow or the day after, but you have to look at what you want done today. Because if you don't, then you're leaving it to the courts and the state to say what your plan is. And most people's plan is not consistent with what the state law would say if you didn't do anything. So that is important to know that you can, do a will now and you can always update it so that you can address it. I was talking to a client today, and she didn't even realize she was getting her estate planning done, and her husband just passed, and so we're updating everything for her. So her statement, and as we were talking about her children, I said, well, your daughter needs to really take care of getting her estate planning done. The situation was her daughter and her daughter's husband, they have three children, and one of their children has special needs, severe special needs. And so I said, if something happens to either one of them and they don't have a will, the state says 50% goes to the surviving spouse, and 50% goes to your children. And you have a special needs child who's getting public benefits, and we don't want those monies to go into her specific account, because then it displaces her from any kind of public benefits that she's getting, because she is has special needs and she has no money personally. And so people just, that's where I'm saying you need your plan and not the state's plan in these cases, and you have that opportunity. So next slide, we'll talk about trusts. And I think we covered some of the things. What are the essential roles of the trust? And these are the different ones. Some I talked about, but the testamentary trust, that is testamentary. That's another word for will, because when you ever hear your last will and testament, well, testamentary trust, are terms and conditions in your will that says, upon your death, create this trust that has these terms. And generally, the testamentary trust is done when people have minor children, and if something should happen to them and that child is under the age of 18, they want that money to be managed for them. And sometimes they say for a period of time, maybe until they're 25, until they're 30 or 35. So that's a testamentary trust. We talked extensively about the living trust. You have a whole lot of real estate outside of different places. You're the trustee. You set it up while you're living. Upon your death, we avoid probate. And that living trust is what we call revocable, because you can change it. It's living, just like you can update your will. You update your will with something called a codicil. When people say, can I make a change to my will? And I said, yes, that change will be a codicil. It is still witnessed, it is still notarized, and it is still signed at the end. Irrevocable. It's a very important trust, and irrevocable means that you can't change it. So I would tell you that when I do irrevocable trust, because I know people change their mind and they're going to come back to me and say, I don't want this trust anymore. I want to change it. And why can't I change it? And why did you do that? And so most of the people who get irrevocable trust fall into two categories. They're my elderly people who clearly know that I really want this to go. This is how I want things to be distributed. I don't intend to move to Florida. I don't intend to move anywhere else. And I want to be able to put it in the irrevocable trust. And so therefore, it is, quote unquote, when you make it an irrevocable trust, it is out of your estate. And when I say out of your estate, that means it is, the person doesn't have to pay inheritance tax. We took it out of your estate, and inheritance tax doesn't have to be paid, but it is irrevocable. You can't change it. A quick question before I go to the special needs trust, which I did talk about already. So I'll talk about the charitable trust. But first, there are people who choose to use free legal documents for wills, POAs online. Do you recommend people use these, and can it be filed legally? Well, thank you for that question. And I guess I'll make it real quick and simple. No, I do not recommend those. But I know that they're there. And I will say to you that I have reviewed them because people have come to me and with their, printouts and said, I tried to do this. I don't know. And then they said, I gave up, and it's not addressing my situation. So what I will say for those is that they're set up, and they try to have, okay, if this, go to this section, if this, go to this section, but they can't imagine everybody's situation. So if you're the average person, and I don't know too many average people, we all have some little work, but it's set up for the average person. When I was in law school, we used to do, and they call it, we used to call it the average man rule. And we always said, it's a straw person. And is that a real person? So yes, it's set up with different categories. And if you can follow and be the average, then it's something to try. Because in answer to your question, you can, that document, as long as signed it at the end, got it witnessed and notarized after you pulled it out. I had another client who bought the documents in and said, well, this is what's in effect now. And now I want to do such and such. And I looked at the documents. I said, this is not what's in effect now. I said, you haven't signed it anywhere. You have witness, you actually have a witness and their name, but you did not sign it. There's not a line here for you to sign. You got a witness and names. So the formalities are sometimes, overlooked. So I just want, and for the power of attorney, now that one is important. I talked about the will and formality and the issues. So average person, but the power of attorney is different for each state. Like the power of attorney in Pennsylvania, when somebody moves, I always tell them, you need to get that state's power of attorney. And those powers of attorneys change. So let's say in 2015, Pennsylvania updated its power of attorney. So the people that I did prior to 2015, I was updating their document. So if you're online and you want to make sure that, okay, it's a 50 state kind of thing, and you're pulling something down, and they say that that's the current one, and long as their person did a 50 state the research properly, then that power of attorney, it would be effective to pull it, to use it, but you want to make sure that it's up to date and is for your particular state. So that's kind of like the whole thing about the online. Yes, they're there, but you don't have that personal back and forth that I think is important. I mean, I think it's very important that you have that dialogue and person listening to you and helping you filter through your particular situation. And just there's a question about irrevocable trusts are tax shelters for your descendants. This is such an important point. Remember when I said testamentary trust, living trust, a living revocable trust. So testamentary trust, when you die, is a trust that's irrevocable. You created it, and the only person that can change a document would be the person that created it. So if a testamentary trust, you die, that trust becomes irrevocable because you can't change it. And it has tax benefits for your descendants, whoever you left it to. That irrevocable trust, when you put it in there and you said what you wanted to happen, if you want it to stay in trust when you die, then that trust becomes irrevocable upon your death. The revocable living trust, when you die, becomes an irrevocable trust if you're going to keep assets in there for a period of time after your death. That's when it becomes irrevocable. Understand that a revocable living trust, you could say in there, upon my death, all of the assets come out of trust to these beneficiaries. But you can also say, upon my death, in this revocable living trust, upon my death, it becomes irrevocable and it stays in there for a period of time for my descendants. Why? It is a tax shelter because it's your asset. It is not your beneficiary's assets. Your assets for their benefit. So if somebody sues them, they can't get the assets in the trust because it's not that person's assets. It is held for their benefits. And the trustee, the language that we always put in there to provide this protection is discretion. We give the trustee discretion to follow some of our guidelines. And so somebody gets sued, well, the person being sued doesn't want to get the money now because it's just going to go into the suit, or getting divorced. That's not an asset. They can't get some of that trust. We call it an asset protection. It is an asset protection. So that's the testamentary trust, irrevocable because you pass. A revocable living trust becomes irrevocable upon your death if you're leaving assets to stand there. If you set up an irrevocable trust and you're living, you've established it, and that is an asset protection. One of the big reasons, or another reason why people do irrevocable trust in the elder care or elder law industry, when people come and they say, I don't want my assets to be used up for a nursing home. And so we say to them, the only way your assets can be protected is you got to give them away. And if you're not going to give them to individuals, then you can give it to an irrevocable trust, because an irrevocable trust is like giving your assets away, and you create an opportunity for those assets not to be considered as yours if you have to go into long-term care. You also have to understand there's the guidelines for monies from Medicaid or for those long-term care require that if you gave anything away, it had to be 5 years ago. So there's some things to be considered with that. So, and there's a question, under what conditions do you have to pay an inheritance tax? I will tell you, in New Jersey, there's no inheritance tax for spouse. In Pennsylvania, there's no inheritance tax for spouse. In New Jersey, there's no inheritance tax for children. In Pennsylvania, there is inheritance tax for children. So upon the death of an individual, the inheritance tax would have to be paid by those individuals that you leave assets to that don't have a zero rate. So if you leave assets to your spouse and to your children, and that's all in New Jersey, there is no inheritance tax paid. But if you leave or your children, your spouse, your children, or a charity, because a charity is zero as well. But if you leave some assets to a brother and sister, then there are inheritance taxes that have to be paid on those assets that are left at the rate in Pennsylvania for brothers and sisters, it's 12%. I'm not sure what it is in New Jersey. And then the other thing listed there, charitable trust, that just means putting money aside for charity. Next slide, and you can let me know in the chat how much more time, so that I really started going on and on. So I want to make sure you get all the information, and if I know how much more time, I'll make sure I get through it. But intestate law, I talked a little bit about this, but it basically means you died without a will, and then the law of the state will apply, and that law would be called the New Jersey intestate law, Pennsylvania intestate law. And the purpose of the intestate law, because they need to know what to do with your assets, and you haven't come up with a decision. So that's why they have the intestate law, because when we don't have a will, we follow what that says. And we name an administrator of the estate because you didn't give us an executor. So we have to ascertain or determine who can be the administrator for your estate. It could be a family member or a beneficiary, but it doesn't have to be. It could be a court-appointed person who is going to be paid out of the assets of your estate. And then in your will, we can always provide that you don't require that your children or be bonded as your executor. But if you don't pick someone, and then the register of wills is going to require that person to be bonded, and bonded basically means if they fail to do or handle your estate correctly, there's like insurance to pay for that. But that's an expense that someone would have to incur, and to handle your estate. The next one is the next slide is the living will, because we're talking about documents in place like the will, which is upon your death, and some of the types of trusts are upon your death. But there are documents that are important while you're living. We did talk about the power of attorney. If you go to the next slide, is the living will. And the living will is it's a very important document. You may have heard and remember the Schiavo case. Terry Schiavo. Terry Schiavo was in a coma or a coma condition for over 12 years because her case went through the whole court system all the way to the Supreme Court. And so a living will tell your family, if you're in an end-stage condition or a permanent state of unconsciousness, what you want as what types of life support you want or don't want. And you name a surrogate, which is the agent to talk on your behalf, because we're saying when you're in a living will state, you pretty much can't communicate. And so that surrogate will speak based on the terms that you've already indicated. Next slide, please. And the role of the medical professionals, I know I sit down and I talk with clients because I'm putting it together, but when they start to really have questions about, well, what is end stage or permanent? What does permanent state of unconsciousness mean? And I said, well, your medical professional is in the best position to be able to have some discussions about that and let you know, so you can have some comfort in doing the document, that you at least understand when we use the term that's in the statute, permanent state of unconsciousness or vegetative state. And so the difference between the healthcare power of attorney and the living will, the healthcare power of attorney is the doctor cannot communicate with you, but it might have been, you just had an accident, been in a car accident, but you're going to go through the process and be well. And so the healthcare power of attorney is a person that the doctors can speak to, can share your medical information with, so that they know what they can do for you and as it relates to your healthcare. And then there was a question, what documents should be put in place in advance to be able to assist elderly parents in the event of emergency? This is one of the important documents to do, the healthcare power of attorney and living will, so that your parents and the power of attorney. So it's technically, the way I do it, it's two documents. It's the general power of attorney, and then it's the healthcare power of attorney and living will. I combine it because I think whoever you name as your healthcare agent needs to follow the process of your illness if you should go into a living will state, because a living, so instead of them having to be brought up to speed, you can have your healthcare agent who's been on board with following your medical advice. It is important that you have these documents, because if you don't have these documents for an elderly, you end up having to go to court and get guardianship. And guardianship is thousands of dollars, where, healthcare power of attorney, living will is a few $100s. And so, because the reason why you end up having to go to court to get guardianship, because when they become incapacitated and they can't do these documents because they have no more capacity, they're either so sick. And I mean, I've had people call me, my mother needs a power of attorney. Are you going to be able to help us? And I say, okay, is she able to come in? I mean, give me some more information. Well, she's in a coma. She's in a hospital. No. I mean, but people really don't understand that. And so that's why I do what I do. People don't understand it. I deal with it every day, but this is, they don't understand. The person who's making the power of attorney is the person who is in the coma. You can't make the power of attorney for the person. So until they come out, and then I determine whether they have the mental capacity to do it, then you're back into going to the court and saying, I need authority to answer and follow through on some of these issues for my parent. So yes, healthcare power of attorney, and living will, and the general power of attorney, very important documents. What is the probate cost for property to children in New Jersey with a will? Yes, once again, you don't have any inheritance tax. And then if you go on their website, because I know the Pennsylvania kind of fee schedule, they usually have it like, if your estate is from 100,000 to 300,000, it will be $400 to do probate. And if your estate exceeds 300,000, then $150 for every $100,000 added. Now, New Jersey, they're going to have their fee schedule, and it would be right there online to tell you what it would cost to go through probate with the will. Because sometimes people are balancing. They are saying, well, I want to avoid probate. But you said it's not that costly, but, so we look at the numbers. And I said, okay. I said, in Pennsylvania, it would probably be for your estate something around $800. It looks like that. But if you do a trust, because the trust is going to be a few $1,000s. It might be $2,500. It might be $3,700, but it's not going to be $800. So the person, it helps them make some sort of decision if that's what they're looking to do. Next slide, please. And we talked about healthcare power of attorney, legal requirements for the healthcare power of attorney. Yeah, it's signed as well. I like to get it notarized, but if it's signed and witnessed, that is sufficient. It's not as important as with the will, where you need to get it notarized. The healthcare power of attorney, just signed and witnessed. And who should serve as your agent? Well, you want someone who can communicate with doctors on your behalf, and that person is someone that you trust. Generally, as family member, it might be the spouse, it might be a child, it might be a parent for younger people. It also could be, some people look at a close relative who happens to be in the medical profession. Well, I'm gonna name my daughter-in-law, she's a nurse. I'm gonna name my daughter-in-law, she's a doctor. So those are the things that you can think about. But most importantly, it's about someone who cares about you, because they will take the time to listen and to read and to be able to give a good a response in helping you in your medical crisis. And then the healthcare power of attorney, you're actually naming that person as your agent, for HIPAA purposes. So that is that language is in your healthcare power of attorney. And once again, the reason why you have it avoids guardianship. And then in the healthcare power of attorney, if for some reason you have a mental health issue, we can expand upon that in your healthcare power of attorney. Next slide. And the next one. The general power of attorney we spoke about that. And once again, who should that be? Because the general power of attorney is the attorney that's handling, or the agent that's handling your financial affairs when you are incapacitated. You are unable to handle your financial affairs. So so some people think, oh, well, do I need someone who's like a financial advisor who understands the investments? And the number one thing I'm back to is trust, because they can get educated on anything that you could get educated on, and they do that on your behalf. But you want to trust them. I've had people to say, well, the only family member I have left is my brother, and I don't know anyone else, so I'm gonna have to name him. And I said, oh, okay, well, you can name him. Why do you have any hesitancy? Well, he's stolen from me before, but maybe he won't do that. I was like, no. If people show you who they are, believe them, and don't appoint somebody that already stole from you. So I've worked with her. to find someone that we could name as her agent. And it was a good friend who was a neighbor. And I put in the provision where you can have a power of attorney that's effective upon your signing of that power of attorney, or you could have a power of attorney that's effective upon a doctor certifying that you're incapacitated. And so we did what we called a springing power of attorney for her. But you don't have to name a spouse or a child or a parent or a relative merely because they are a child, a parent, or a relative. They, number one, they are, trust somebody you trust who would take care of you. And if they haven't been trustworthy in the past, they probably won't be trustworthy in the future. Next slide, please. And I talked about the role, the power, very important. On the first page, and I think it's also in New Jersey, on the first page of the power of attorney, they ask the person making a power of attorney to sign that first page. And on that first page is statutory language that basically requires for you to read. And it says, your agent has full authority to do anything that you could have done if you wanted, if you were able to do it. They can sell your property. They can take money out of your bank account. And so some people are like, wait a minute. I don't want to put that. I didn't realize. Well, yeah. So they have those broad powers. So I go back to what I've said, trust. You want to be able to, because they have the same power that you have, and you're giving it to them. And then next page, please. And okay, so that's any questions. And I see that there was another question. How do you go about getting a healthcare power of attorney, living will, for a special need adult? Thank you for the question, because if that's, I have done documents for special needs children, but it all depends on how extensive their disability is. And so, parents brought their son in. He's an adult child, and he has, special needs, but he has a job. He can take the bus and go anywhere that he wants. And so we could have a dialogue, and I can do his documents. So special needs individuals go to spectrum. And so if they're at a point where they cannot understand what the document is, and they cannot understand the role that I'm playing in putting the document together, then they cannot sign the document. They don't have the capacity. And in many of those cases, families get guardianship. Because there have been, many cases, and I get guardianships. I do guardianships. I get guardianships on the young end when a child is going into adulthood, and they've been, special needs all their life, and their ability to function is very limited. And the parents, when that child becomes an adult, has limited rights. Sometimes the state will intercede and do things that the parents don't want. And the only way the parent can have control over that is they have to become the guardian. And that's something that I know it sounds strange, but become the guardian of their own child. But yes, so that's why I said, depending upon the special needs nature of the adult that you're speaking, that would be the situation. Are there people, here's a question, are there people at banks or other commercial places that can serve as trustee if a person really does not have anyone in their life that they trust to handle their affairs? Answer to that question, yes. I mean, they're trust companies. You'll have a bank, like we have First National Bank and Trust. And that's what it means. That means that they can serve as a trustee. And people do look at their banking institutions to serve as trustees. And sometimes what they'll do, even if they have someone that they want to name, they feel a lot more comfortable having a name, maybe naming code. They'll name the bank along with an individual, and they could work together. And then obviously we're dealing with the longevity of a financial institution, and you're looking at, having assets that you want to spread over a period of time. You might have somebody that you're naming now and realizing that if something happens to them, you want to have some sort of backup. So you can name institutions. There are, some financial advisors will serve, some see it as a conflict or can't serve. Some lawyers will serve, some lawyers do not. But, yes, so there are professional trustees that can do that work for you. What are some of the common mistakes that people make when doing estate planning? Not keeping it up to date, not anticipating the disharmony that might occur with some of their decisions. And so, not taking the necessary precautions as a result of what these decisions may do and being able to rectify that. So the other big thing is, it's kind of the things I went through to encourage you to do is not, losing the document. This is important. If you want to change your estate planning document, do not mark up the ones that you have, because if you mark on the ones that you have voided out those documents. So you would not have anything in effect. So when you want to make a change to your document, you need to do a new document if you went online and did something, or contact the attorney and get your document updated. That is a big mistake. And I do see people, and I mean, there are ways to kind of, like, if the person died and they made some notes on there, we have to go through a process and a petition, and we have to bring witnesses, and sometimes that doesn't work. Sometimes the register of wills just won't accept it because, you made a change on page 1, you struck out somebody's name and you wrote somebody else's name. Yeah, they don't know who did that because you didn't go through the formalities. Anybody could have done that, strike out somebody else's name, put your name in there. So that's a big mistake. So do not mark up your document, get a new document, change it, amend it. And the other thing that people often do, and I didn't even get a chance to talk about, I have a pet peeve. I do not like especially co-executors. And people with children, they all are like, I don't want to treat my children differently. I want to treat them all the same. And I have 5, and I want all 5 of them to be executors. So they can be co-executors. They'll work it out. Well, no, they won't. And so even with 2, I just say, name a primary and then an alternate. And we have so many roles that you can have other roles for your children. You can name 1 the primary executor, 1 the alternate executor, 1 the power of attorney, 1 the alternate power of attorney, 1 to handle healthcare. And so I really try to get them to put them out. And I only say this based upon experience. The legal fees, my legal fees to families in estate administration always are more when there are multiple executors. It just happens. The big one is when they don't get along. Obviously, I can't talk to them in the same room. I have to have separate meetings, and that costs. And then you have those that they do get along, but their time schedules are just different. And so, we wanted to get around to signing the inheritance tax return. Well, it took a couple extra weeks, sometimes an extra month, because one was available and the other one wasn't available. And they're trying to work it out. But life, I mean, they all have their own families and they all live somewhere else. So that naming multiple agents for yourself and or as executors, that's a common mistake, and that I really try to talk families out of doing. But ultimately, it's your will, and I will follow that. Can I ensure that the assets I want to go to my adult kids are not impacted by their divorce? That's a good question. It goes back to asset protection, and so that's why sometimes when I'll say, do you want to, the assets, do you want to leave them outright to your children, or do you want it in a trust? And I'm talking about children that are already adults. So they come in, they're doing their estate planning, their kids are all married with children. And we still do a trust because they want to create an asset protection. And so that's how they would do it. That's the only way. Once you give it to them outright, it becomes, an asset of theirs that the divorce proceedings could impact. Unless make sure you can also say to your children, when you're getting married, you might want to do a prenup that would exclude any inheritance you're getting from your parents. So that's another way to do it. Another question: what advice would you give when it comes to wills, trusts, etc., for married couples that do not have children, but children from another relationship? Yes, that's what we call our blended families. And that's where trust is very, very important. You have to do a trust because the husband and wife, they want to take care of each other. But they say, if something happens to this person I want to take care of, I want the money to then go to ABC or to my children. And the only way you can do that is with a trust. So I do have to do those types of trusts often because, if you leave it to one, it's not saying that the person that you married is not going to share with your children, just going to give it to their children. That could be the case, but it's not saying that. That person could remarry, and then you got all of that mixed in. So you want to keep that money separate. You create a trust. Upon the death of one, it stays in trust for the benefit of the surviving spouse, health, maintenance, and support, and whatever they may need for health, maintenance, and support. And if for some reason they end up having to use it all, but it was for them, and that was the person that you wanted to take care of. But if there's still money left, it will go to who you say in the trust it should go to, and whether that would be your children, and vice versa for the other spouse, to their children. So that is an important feature in estate planning, and why a lot of people definitely come when they're going into a second marriage with children. And I think those were all the questions, and I just want to make sure if we have any other questions, feel free to put them in the chat, and I will answer them. And what is the minimum product when it comes to estate planning? What is the minimum available? I'm not sure. Could you do that again? What is the minimum product when it comes? What kind of product are you asking? If your question is, at a minimum, what should you get when you're doing your estate planning? I really encourage you to do the will, the general power of attorney, and the healthcare power of attorney and living will. Those are the basis of your estate plan. And then you build from there with the different types of trusts, depending upon the special circumstances that may exist in your family dynamics and your assets. So you definitely want to have those 3 documents. I always package those documents together, because it should just give you a will is overlooking the importance of a general power of attorney and a healthcare power of attorney and living will. Well, I really greatly appreciate your questions. I mean, when I wrote my book, Stop, What Are You Waiting For? Your Step-by-Step Guide to Estate Planning, a lot of it came out of, seminars that I did, and the questions that were so great to help me kind of put those things in the book to help people out. And the cost of the documents, there you go. What does all of this cost me? Well, when you have an attorney do your estate planning, and I've made it a part of my practice when people call to let them know exactly what their costs would be, because I can package certain things, and other things I charge an hourly rate. So just so you get an idea, if you were to call me and you wanted your estate planning done, and I told you I do the package, which is the will, the general power of attorney, healthcare power of attorney, you're looking at $1,250 to cover that for individuals. And then that process is, an intake discussion. I get to know you, I get to know the issues, and then another opportunity, because you get draft documents for you to look at those documents and say, well, I don't understand any of this now. And so we have another discussion to answer it once you have documents in front of you. And then the final one is when you come and do it. And so, attorneys can work on an hourly basis. Hourly rates can be from $300 to whatever, but it's important for you to ask the question before you're actually sitting in the office. And if they can't tell you that I don't like that practice. I mean, I if they can't tell you how much it's going to be, and I'll say things like, here's the package. Now, if you have special circumstances, it could be enhanced with this, that, and the other, but they've at least heard a basic figure. And so I think that that's important.
Wow. As they say, did not our hearts burn? Right? We enjoyed it so much. Thank you so much, Yvette, for coming on and providing so much insight and value to all of our members, to all of those folks who are not members, and just chiming into this financial session on Facebook, on YouTube. I don't know if we're streaming it to Twitter and Instagram too, but we're everywhere tonight. And we appreciate you all for taking a part of this. I know Tasha talked about this earlier, about some of the other things that are coming up. Please avail yourself to the sessions that are coming next. But I'm going to turn it over to Tyretta and allow her to close us out.
All right. Well, thank you again, Yvette. Cornell, thank you. But I really appreciate all that you shared with us on tonight. And we thank everybody who joined us. I'm going to close out in prayer. Father, we just thank you for this time of learning, this time of educating us, how you poured into us about something that is very practical as it relates to our money. And Lord, we thank you that you are the God of all areas of our lives, including our finances. And so we pray that we take this information forward, God. We thank you for the seed that was planted tonight, but now give us the diligence, the skills, the connections, and the discipline to move it forward and to put some things into practice that need to be done for each of us, God, so that we can leave the legacy, not just spiritually, not just financially, but even for our assets, and we can protect ourselves and protect our families in the future. We appreciate you. We appreciate all that was shared with us tonight. We appreciate every single person who decided to join us in this educational experience, God. And we pray that not only that we leave the legacy in our finances, but help us to leave the legacy in the knowledge, Lord, that we are able to share these things with our family members and our friends, Lord, that we can take this forward and we leave a legacy in those areas as well. We thank you. We praise you for all of these things, for being our God, our Savior, for protecting us, for keeping us, for giving us wealth, and helping us to protect that wealth. In Jesus' name we pray. And we especially pray for Yvette, God, that you would just continue to bless her as she shares with the community and shares with people at large this information. Just continue to just help her in any area that she needs to, so that she can continue to be a blessing to others. In Jesus' name, amen.
Amen. Thank you. Thank you so much, Yvette. So much information. I learned so much, and we greatly appreciate you. And you have a great evening. We thank you for taking the time out and everything. And I thank you, Cornell, for facilitating this session. I thank you for being the best that you are. And Tyretta, thank you. I love you all. And be blessed. Please tag, share, send this to everyone that you feel, like I said earlier, that may need this information. Share it on a Thanksgiving dinner. And and share with your family, because all this information was greatly appreciated. Thank you so much. And everyone have a good evening.
Thank you. Thank you so much. Bye-bye.